Good evening, everybody. My name's Eléonore Berthelsen. I am a private law family practitioner at 42BR. With me today is the wonderful Krishma Patel. She is also a member of our private law team. So this is the first seminar in our private law series. Just a further point, we don't do slides. We don't like them. We find that our attention wanders when we're looking at slides. But what we will do after the seminar is circulate a list of the references to the statute, the procedure rules, also the practice directions and the leading cases. So you should have a half-page guide with all the references that you're going to need when approaching the issue of section 9114. We're going to be speaking about it for around 30 minutes or so. It's a relatively discrete area of law. It's a very important part of the toolkit that we have as family law practitioners. But also this talk will provide fair warning basically to those at the receiving end of such applications, and there should be some helpful pointers as we're going along, which can assist with case strategy.
And now, Eléonore, can you tell us why is this topic so relevant at the moment?
Well, I'll go back to the subtitle of the seminar, which is, can you make it stop? And the answer to that question is, well, can you make somebody stop making repeated applications and stop the sometimes pernicious cycle of litigation? The answer to that today is yes, possibly more easily than a couple of years ago. And so what we're going to be talking about today is section 9114 orders, which are also sometimes slightly inaccurately known as barring orders, which are orders which effectively help prevent people from making repetitious applications to court. The reason why it's relevant is not just because the change in the law has come in relatively recently. There has also been a few more decisions in the High Court which assist us with interpretation and highlight the importance of this topic. And it's particularly important because you'll still find magistrates and judges who believe that a section 9114 is very much the exception to the rule. And the new law, which came into force in May of 2022, makes clear that that's really the wrong way of thinking about this issue. So part of that is because our understanding of domestic abuse has really shifted since the Children Act came into force in 1989. The leading case in relation to section 9114 until very recently was a case called Repeat, which still has application. We still need to talk about it, and we'll be talking about it in the course of this seminar. We have a lot more awareness of the issues of domestic violence and also of the way in which the court processes can be weaponized as instruments of abuse. And there are other examples in which we know that things have shifted, because we're all private law practitioners, we all know this. So special measures is an important one. Yeah. We have qualified legal representatives to cross-examine victims of domestic abuse if you can find one, but in theory that is something that's supposed to happen. So really, not just in the panoply of the tools that we've got to regulate what happens in court, are we aware of what happens, the wider aspects of domestic abuse, but also the categories of domestic abuse, which now include harassment and controlling behaviour, which seems old hat now, but in 1999 it wasn't a thing, and things like financial abuse. So really it's part of that wider trend. So again, section 9114 and its amplification in the new section 91A, which we're going to be talking about in the course of this seminar, is really all about trying to prevent parents using the court system as a means of perpetuating abusive behaviour by forcing a person into a confrontation which they cannot elect to walk away from. But actually, the categories of abusive behaviour, I think we have a much better understanding of. They are specified within the statute, and we're going to look at that in a moment.
And so you mentioned Repeat. Yeah. Are you able to take us down a little journey down memory lane and tell us what used to be the law? Yeah,
absolutely. So we're going to start with section 9114, which is obviously still the applicable statute, but it's been amplified. So section 9114 reads that on disposing of any application for an order under this act, that being the Children Act 1989, the court may, whether or not it makes any other order in response to the application, order that no application for an order under the Act of any specified kind may be made with respect to the child concerned by any person named in the order without leave of the court. Just to break it down a little bit, effectively it's, even if the court doesn't make an order on the substantive application, it can make an order requiring somebody to have to ask for the court's permission if it wants to make a specified type of application, whether that is a child arrangements order, a specific issue order, or some other kind of order which is set out within the Children Act, although we are primarily today concerned with Section 8 orders.
Yeah.
So it's there really to act as a brake, and it sort of apes the provisions that you might have in civil proceedings to prevent vexatious litigants from causing a nuisance and wasting court time and causing distress to people. I should say that civil restraint orders are available in the family law system, but overwhelmingly people are more concerned with using Section 9114. It's a much more straightforward instrument. So when we only had Section 9114, the leading case in relation to that was a case called Re-P. And the reason why I am going to discuss Re-P, despite the fact that things have moved on a little bit, is that some of it is still applicable today. It's also an easy way of illustrating the cultural shift that has taken place. And so we still need to know what it says. So this was a judgment of Lady Justice Butler Sloss in 1999. And it's a case which decides that the court always has to carry out a balancing exercise between the welfare of the child and the right of unrestricted access to the litigant to the court. And it sets out guidelines that were based on the earlier decisions, so preceding 1999. It remains cited in the family court practice, so that's the Red Book. And as I say, it does contain helpful advice, but it comes with a health warning because, as we will see, things have changed somewhat. And actually that shift happened even before Section 91A came into force in 2022. So an interesting point about that actually is when I was rereading this case, I haven't read it for some time in detail because it's sort of old hat, we all sort of know what it says. The case refers to the parents as natural parents rather than birth parents. And it really struck me because that's just a term that we wouldn't use anymore. And 1999 doesn't actually feel like it was that long ago.
Yeah.
Krishma, I feel old.
Me both.
So the case concerned an application for a residence order, what's now a lives with order, which had been made in favour of the child's foster parents. The application for the residence order made by the birth parents. And they wanted to see the child to be brought up in their own faith. And we don't really need to get into that because the case decides that point separately. What we are concerned with really is the guidance which Re-P sets out in relation to Section 9114. So the guidance, number one, Section 9114 should be read in conjunction with Section 11 of the Children Act 1999, which makes the welfare of the child the paramount consideration. Still good. Number two, the power to restrict applications to the court is discretionary, and in the exercise of its discretion, the court must weigh in the balance all the relevant circumstances. That's still good. Number three, an important consideration is that to impose a restriction is a statutory intrusion into the right of a party to bring proceedings before the court and to be heard in matters affecting his or her child. I might call that the Article 6 point. / Article 8. We then have number four, the power is therefore to be used with great care and sparingly. It is the exception and not the rule. Now, mark you well that phrase because we're going to come back to it. Number five, it is generally seen to be seen as a weapon of last resort in cases of repeated and unreasonable applications. Again, remember that. Number six, in suitable circumstance and on clear evidence, the court may impose the leave restriction in cases where the welfare of the child requires it, although there's no past history of making unreasonable applications. So there are a few other provisions, but really those are the main ones that I wanted to look at, because particularly in relation to number 5 and 4, things have significantly changed.
Okay, and can you tell us a bit about why the law's changed?
So I explained before that there had been a change in culture, and we've all felt it. It's all been in the media. We're all sort of very savvy about those things in general. So it's reflective really of a wider change in culture and understanding of abusive behaviour. In 2019, there was a public consultation by the Ministry of Justice, and they published a panel report assessing the risk of harm to children and parents in private law. And that is sometimes known as the harm report for short, which is, obviously hugely cheering. And it's all about assessing risk of harm to children and parents in private law children cases. It's a report that's 216 pages, but it's okay. We've read it, so you don't have to. And effectively, it reflects the findings of an expert panel and provides an understanding of how effectively the family courts identify and respond to allegations of domestic abuse and other serious offences. Small bracket here, we're obviously well aware of practice direction 12J and how things have moved on even in the last 10 years, so preceding the harm report. The report recommended that in order to protect children and victims more effectively from harm, there should be an amendment to the Children Act to reverse what was described as the exceptionality requirement that was laid down in REP, and to enable orders to be made where the court finds that bringing or prolonging proceedings constitutes domestic abuse. And so because of this, there was an additional item that was added to the Domestic Abuse Bill when the Domestic Abuse Act 2021 became law. That was section 67 of that act, which is the amendment to the Children Act, which we're going to be talking about in a moment. And that amendment, which is section 91A of the Children Act 1989, came to force on the 19th of May 2022. So in other words, what was concluded at that point by this expert panel was that section 9114 wasn't really working as effectively as it could be, and really it should have much wider application.
And was there any sense in recent case law generally that things perhaps were moving on anyway? When you were looking into things, were there any trends in a case law that you could identify? Any decisions which, if you look at them now through the prism of 91A, they need to be treated with caution, for instance?
Well, there's what is effectively now the leading case. It was decided slightly before section 91A came into force, but clearly contemplating that it was about to come into force. And this was a decision called RE-A, brackets, a child supervised contact, section 9114, Children Act 1989 orders, case decided on the 23rd of November 2021. But for any people who've joined us just after the seminar started, please don't worry about the citations. You will be provided with them. You will have a half-page quick guide to all the cases that we're citing and also the relevant procedure and bits of statute that you need. So RE-A was a decision in which Lady Justice King was the lead judge. It concerned a mother in private law proceedings, which concerned her 7-year-old daughter. And she was appealing against an order for contact, which only granted her supervised contact with a child, the court having decided that her 7-year-old daughter should be living with her father. And it also further made an order prohibiting the parties, that's both the mother and the father, from making any further applications under the Act for 2 years without the court's permission. And in that case, the Court of Appeal really tried to put some guidelines in a more modern context. So the REP guidelines were given a bit of an update. And it's really worth looking in detail at paragraphs 33 to 42 of that judgment when you're considering whether or not to make an application for section 9114, or you think it's something that might be applicable to the case, because it's full of really quite helpful stuff. I'm not going to read out those paragraphs in great detail because we're going to massively go over on our talk if we do. But I'm going to give you some of the edited highlights of some of the matters that were raised in that case. So the Court of Appeal, in summarising the facts of the case, pointed out that the original trial judge had summarised endless applications and the deluge of email correspondence by this mother, mostly from her during the course of the proceedings. There were emails making allegations against the father that were sent to the court, school, the GP, social services, and also to the police. She had also, interestingly, made formal complaints about one of the expert witnesses in that case, a psychologist. She had also made complaints to other professional bodies, so the solicitor representing the child and also the child's guardian. So really like the full gamut of all possible, I mean, but clearly somebody who had a high tolerance for emotional stress. And informal complaints were also made towards the counsel who was representing the child. By the time the matter came to trial, the papers were 6 art trials long. It was actually a fairly straightforward case. And so the Court of Appeal had to decide whether or not the mother's application for to appeal the decision imposing the section 9114 on her for 2 years should be allowed or not. And this is what they had to say about REP in applying the law. The guidelines had stood the test of time, but the forensic landscape had changed out of all recognition since they were made, particularly with the advent of the smartphone, social media, and email as means of instant communication, and the withdrawal of legal aid, so that a lot of parents who would otherwise have been represented no longer had that, and that meant that there wasn't anybody basically to tell them to take a sanity check, sense check, and stop them. So I go back to what I was saying before, the huge cultural changes that occurred since 1989 and also 1999, cultural changes in the way that we view domestic abuse, but also, of course, the deluge of social media that we've had since that time. So the Lady Justice King concluded that it wasn't uncommon in private law proceedings for the parties and the judge to be bombarded with emails from an unrepresented party. I'm sure we all know that. And it could be for all sorts of reasons. It could be anxiety, or it could be a campaign by one parent against the other. But in any event, it's deeply distressing and damaging, and it particularly can be debilitating to the parties and also to the children. So guideline 5 in REP, which refers to a useful weapon of last resort in cases of repeated unreasonable applications, had more resonance now really than it does in 1999. It's not with guideline 4, which is about it being the exception rather than the rule. What it had led to was a misplaced reluctance to use section 9114, except in the very worst cases. Lady Justice King also observed that the court's jurisdiction to make section 9114 was not limited to cases where a party had made excessive applications, but also situations where a party's overall conduct merited intervention. So I refer you back to what the mother in Rie had done, which was a deluge of email correspondence and complaints against numerous professionals to their regulatory bodies, and also emails to the judge, the court, and the like, and complaints, complaints about the father. The decision in Rie also links that back to the fact that section 9114, as suggested in guideline 6 of REP, provides that courts could impose the leave restrictions where the welfare of the child required it. This case clearly involved complaints that were made against the father, and Lady Justice King commented that the sort of harassment that he had experienced in the form of vindictive complaints was exactly the sort of case where section 9114 was appropriate, even without numerous applications having been made. So that is in a potted summary, really, of the broad arc of her decision. She did note within her decision that the new section 91A had not yet come into force, but that this new provision supported what she described as the court's modern approach to section 9114 orders. So going back to your original question, which was, well, was there any sort of hint in the case law that things were shifting? Yes, there absolutely was. And Rie is the case that you should be reading because it tells you what you need to know. So short guide to what Rie says about categories of case where you might want to make an application or where an application might be warranted. So meritless applications, even where there isn't an excessive number of applications having been made, because it protects the child from the effects of unproductive applications or a campaign of harassment by an absent parent. Also, interestingly, she notes that it could benefit other children whose cases are delayed as court lists are clogged up by meritless applications. So it's an example of the court using its case management and reporting its duty to consider all other cases and allocating their resources, which is interesting. Also, where a party's conduct has been inappropriate, so I refer you to the excessive emails and complaints to regulatory bodies. And she mentions the third category, which is cases in which the proceedings have effectively been used by a party as a form of coercive control, which is interesting because that is exactly what the harm report was aimed at. So just very quickly going on to the President's guidance, which you should also be aware of, just as an extra boost to the relevance of section 9114. On the 28th of July 2022, so it's about 2 months after the new section 91A came into force, the President provided guidance in respect to the amendment, which makes it clear that threshold has been lowered for the making of orders under section 9114. So what does section 91A say? Well, it provides as follows. It's clear that it is in amplification to section 9114. It sets out that the circumstances in which the court can make such an order include, among others, where the court is satisfied that the making of an application for an order under this act of a specified kind by any person named as in section 9114 order would put the child concerned or another individual at risk of harm. So we're not looking at exceptionality here. We're really looking at something which is quite similar to the sorts of provisions within PD 12J. It's not egregious cases. It's a common or garden phenomenon, because we can think of any number of cases where harm would be something that the court would want to consider. So the provision goes on to say that in the case of a child or other individual who's reached the age of 18, the reference to harm is to be read as a reference to ill treatment or the impairment of physical or mental health. Pausing there for a moment, it doesn't say domestic abuse, although it clearly contemplates it, but it could be something that stops short of it, and it might just be litigation conduct, which is something which is discussed. Where a person who's named in such an order applies for leave to make an application of the specified court, the court must, in determining whether to grant leave, consider whether there has been a material change of circumstances since the order was made. So here we have a bit of guidance. If you're going to make a leave application, what do you need to satisfy the court of? So there's a bit more guidance to courts, but also to potential litigants about what they need to be looking at. A section 9114 order may be made by the court on an application by the relevant individual. So I noted before that this could be a party, but actually I suppose it could also potentially be a non-party if they're going to be affected by the making of such an order, by or on behalf of the child concerned, or by any other person who is a party to the application being disposed of by the court. It can also be made by the court of its own motion. I paused here to note that there was a time when this was seen really as a bit of an exception, this point about section 9114 orders being made of the court's own motion. So let's have a look at how RE-A and this new guidance compares with RE-P. So I enumerated the various points in RE-P earlier. We're going to go through them again. Point 1, that section 9114 needs to be read in conjunction with section 11, so welfare of the child parent consideration. That holds. Number 2, power of the court to restrict applications is discretionary. The court must weigh and balance all the relevant circumstances. That holds. Number 3, an important consideration is that the imposition of the restriction is a statutory intrusion into the rights of a party to bring proceedings before the court. That holds. Number 4, the power is therefore to be used with great care and sparingly, the exception of the rule. Kind of gone. And it then follows number 5. It is generally to be seen as a weapon of last report in cases of repeated and unreasonable applications. Also clearly, that's gone. But please do look at RE-P. There's still some good stuff there, but clearly things have moved on since that time. So just going back to the considerations of how things have changed, there's a recent case called F and M. It's decided in 2023 by Mr. Justice Hayden. He has described section 91A as transformative. That particular case that he dealt with actually did involve various extremely severe controlling and coercive behaviour findings. But it was interesting that he used that word transformative, because I think that is our cue for how common these applications are going to be in the future. So I think that we better turn now to the question of the procedure, which is the nuts and bolts and the really useful stuff that people are actually going to use. So Krishma, sorry, when should you consider making an application?
So typically it's considered perhaps towards the conclusion of proceedings, having said that, there's actually nothing preventing you from introducing it at an early stage. It just may not be determined until the end. And in terms of how you actually go about making such an application, so you'd make it formally in Form C2 pursuant to Part 18 of the Family Procedure Rules, or you could make it orally to the court, or the court can raise it of its own motion.
So that's the Section 91A.
Exactly.
Explicitly sets that out.
Exactly, exactly. But when if you are considering making such an application, then you should consider the guidance that's provided in Practice Direction 12Q, and it does actually provide a quick guide to 9114 orders. And if you do make such an application, it may be worth citing it in full in a position statement.
Yeah, just in case you get a tribunal who still thinks that the old law is applicable, at least for a time. Hopefully sooner or later we'll stop having to remind them, but for now it's a useful pointer.
Yes, I would completely agree with that. But there are effectively there are orders that are available to prevent a person from making future applications under the 1989 Act without leave of the court, and they are not a complete bar. They're actually a protective filter, and the orders are made if it's in the interest of the children. The court has got a discretion to determine the circumstances where an order like this would be appropriate, and those circumstances may be many and varied. So, for instance, they could include circumstances where an application would put the child concerned or another individual at risk of harm, and that's provided for in 91A, such as psychological or emotional harm. But headline point is the welfare of the child is paramount. But the circumstances can also include where one party has made repeated and unreasonable applications, or, for instance, where there is a period of respite needed following litigation, or there's a need for a period of time for certain actions to be taken for the protection of the child or other person.
So I suppose that could be if somebody needs to go off and get a bit of therapy, or
exactly,
whether that is the disappointed party, or the child or whoever. Okay, that's interesting.
Exactly. Or, for example, where a person's conduct overall is such that an order is merited to protect the welfare of the child directly or even indirectly, and that may be due to damaging effects on a parent carer, for example. Because such conduct could include harassment or oppressive or distressing behaviour within the proceedings. That could include social media, email, etc. It may be also conduct by third parties, and that conduct could constitute domestic abuse.
Yeah, do you know, it's really interesting, because I think actually that it includes domestic abuse, but actually also probably includes all sorts of other behaviour.
Yeah,
and that's interesting because that comes up all the time, doesn't it?
Yes, it does.
And you always have people saying, you know, oh, he's got his whole family writing about me on social media.
Yeah.
Is there any way of making it stop? Well, potentially, actually, there might be.
Yeah, absolutely.
Okay.
Also, just on that point, a future application could also be a pattern of coercive or controlling behaviour or other domestic abuse towards a victim, such that a 9114 order is merited due to the risk of harm to the child or other individual. And that's now recognised, and it's noted within, actually, Practice Direction 12J, paragraph 37.
Yeah, so actually that's interesting, because we go back to this issue of domestic abuse, don't we? And how that is treated so differently now to the way that it used to be.
Exactly. Now, just in terms of 91A, there isn't a definition in terms of who the other individual could be that could be put at risk of harm, but it's most likely to be, but not limited to, a person that's got parental responsibility for the child, or is living with or has contact with the child, or any other individual who could be a prospective respondent to a future application. The practice direction actually does say that in proceedings where domestic abuse is alleged or proven, or where there are allegations or evidence of harm to a child or other individual, that the court should give early and ongoing consideration to whether it would be appropriate to make a 9114 order on disposal of the application, even if an application for such an order has not been made. Again, going back to the courts on motion.
But also interesting, well, it's just that, it's placing that responsibility back on the judge rather than expecting the parties to come up with it. And I imagine that would be very helpful to litigants in person, where the court just has to step in because really enough's enough, and hey, these people need help.
Yeah.
Okay.
Yeah. And as I've said, there are a protective filter as opposed to a bar on applications. Proceedings under the 1989 Act should not be used as a means of harassment or coercive control or further abuse against a victim of domestic abuse or other person, and the court should therefore give due consideration to whether a future application would have such an impact.
What about case management?
So in terms of the relevant procedure to follow, it's set out at paragraph 3 of Practice Direction 12Q, and it effectively restates that a 9114 order can be made by the court of its own motion, as we've been discussing. If the court is considering it at any stage in the proceedings, it must record this on the order together with any related directions. And those related directions are dealt with, for example, at paragraph 3.5 of the practice direction, and they may include consideration of what opportunity for representation should be provided to the parties.
But no surprises. Everyone gets a chance to have their say about.
Exactly.
Okay.
And actually, the practice direction does actually say that the court should look to case law for further guidance and principles.
So REPI and REA.
Yes.
So what about the factors that the court takes into account when making its decision? Because we've talked about lots of the scenarios where it should maybe be considering making an order, and we've spoken about typical scenarios, but is that something that you can expand on a little bit maybe?
Yeah, so actually the factors, if you look at paragraph 3.6 of PD 12Q, sets out matters that the court should give consideration to when the court's considering making a 9114 order. So the first thing that's raised there is the duration of the order. Now, the statute is effectively silent on the duration of a section 9114 order, and the court has got a discretion as to the appropriate duration. But PD 12Q does state that any time limit imposed should be proportionate to the harm that it's seeking to avoid. And if the court, again, decides to make a 9114 order, then the court should explain the reasons for the duration that has been ordered. Now, duration, as I've said, it is discretionary and it's a matter of proportionality, but it's going to differ on a case-by-case basis.
Okay.
The other point that is made in paragraph 3.6 is that the court should consider whether the order should cover all or only certain types of application under the 1989 Act. And the statutes 9114 and 91A give discretion to the court as to the types of applications under the Children Act that can be made subject to permission from the court. So if the court does decide to make the order, it should be specified. Do they relate, for example, to variation, enforcement, specific issue orders, etc.?
Okay.
That should be specified. Another consideration is whether service of any subsequent application for leave should be prohibited until the court has made a determination of the merits of such an application.
So that's, I mean, that goes back to the can you make it stop?
Yes.
Because that clearly contemplates a scenario whereby the potential recipient of an unwelcome application isn't even made aware of the fact that the application has been made until a judge has looked at it and worked out whether or not the case has got legs.
Yes,
okay,
effectively. And there's further provision about that in paragraph 6 of PD 12Q. But effectively, such an order delaying service would help to ensure that the very harm or other protective function that the order is intended to address is not undermined, and that's effectively the point of it. Another point that needs to be considered by the court is whether upon any subsequent application for leave, the court should make an initial determination of the merits of the application without an oral hearing. And paragraph 6.5 of the practice direction also says the court should not ordinarily direct a report to be prepared under Section 7 of the Children Act 1989, in particular, since if leave were granted and the specified application were made, the court would then consider such direction to be appropriate.
Okay. So I just wanted to go back to something you mentioned just now, which is the point about determining the application on the papers and without an oral hearing. That's quite similar, I suppose, in nature to an application for leave to appeal. So that's also interesting. It's sort of introducing that we're not going to make the other side start paying money for legal fees unless we really have to, which I suppose is another way of protecting them from abuse.
Yeah.
Okay.
Absolutely. Absolutely.
So in terms of the leave application, are you able to say really how that works, the application for leave? once, you know, the court has determined,
Yes.
section 9114, you're not coming back, we don't want to hear from you, we're trying to protect the children or protect the parties or whatever. What does that look like when you make that application? Where do you start?
So if you are the named person within
Yeah.
a 9114 order and you want to make an application for permission to make a further application under the relevant act, as I've said, a 9114 order is not a complete bar. It doesn't entirely prohibit it, but it does require for the recipient of or the person that's named in such an order to apply for permission.
Okay.
As I've said. Now, how do you do that? Practice direction 12Q again. Paragraph 6 deals with this. And what it says is that the application for leave must be made using Form C2 with 2 attachments. And those attachments are 1, a draft of the application for which permission is being sought, and 2, a witness statement that sets out the ground upon which permission is sought, including, importantly, whether there has been a material change of circumstances since the court made the 9114 order. And just a point to hear that the Part 18 rules in terms of service of any applications applies here in terms of an application for leave. But the guidance is effectively contained in paragraph 6, and paragraph 6.4 in particular says that in determining any application for leave, the court has got a discretion, as to the circumstances in which leave should be granted. And that section 91A4 requires the court to consider, as I've said, whether there has been a material change of circumstances. But it does say that a material change of circumstances is not necessarily required for an order for leave to be granted, but that question of whether there has in fact been such a change is something that the court must consider.
It's difficult to envision a scenario where that wouldn't be relevant unless, I mean, clearly something would have changed.
Yeah.
Otherwise, your application is almost bound to fail, isn't it?
Indeed.
Okay.
Indeed. The court may, and this is at paragraph 6.6 of 12Q, practice direction, the court may make an initial determination without an oral hearing of the merits of the application for leave. And if the court does so, the applicant may, within 7 days of receipt of the notice of the court's decision, then request an oral hearing. If the court does receive a request for an oral hearing, it must make directions as to the service of the application, and just coming back to your point of service of the application, and any other documents on the respondent, including the possibility that the respondent would not be served and as to any representations or other matters in relation to the oral hearing. And the court should, in terms of granting leave, only grant permission to make the application if it deems that the application has merit to succeed.
So there is actually a recent case in relation to that, and was decided by the President relatively recently, and it is a case called Re-S. The citation is 2023 EWHC 1161, and as I say, it's a decision of the President, which just summarises the test, which is, does the application demonstrate that there is a need for a new judicial investigation, and can the applicant persuade the judge that he or she has an arguable case with some chance of success? So it's becoming quite clear what it is that you have to do if you want to get over that threshold, if a section 9114 is the bar to your making a further application. So there are, I think we promised that we talk for about 30 minutes. I've just realised I'm so sorry. But that was, I think, a very quick trot through section 9114. So the headline points being, first of all, read the statute, make sure that you have that test in mind, remind courts, whether it's legal advisors, magistrates, full-time judges, let them know that this is an instrument within their arsenal. Of course, if that is going to be to your advantage. If it isn't, then make sure that you advise your clients about it, that there are real risks to pursuing litigation in a really aggressive way or in an unhelpful way. And that might actually help them as much as anyone else to ensure a good outcome, because people are still listening to what they have to say rather than just shutting down because they're just argumentative or not helping themselves by being very aggressive towards other parties. Do read REA. Very important that you should do that. It contains very important guidance. And just be aware, generally speaking, that I think we can expect to see a lot more of this. There are more and more reported decisions that are coming through in relation to Section 9114. They all broadly say the same thing, which is this is a transformative piece of legislation. It is going to become a lot more commonplace, and therefore it is up to us really to ensure that we know how to use the law. I suppose it's arguable that Section 9114, as it was originally couched, was perfectly okay on its own, but then the way that the case law qualified it put people off using it, but we must be aware of it. That brings us to the end of this seminar, and we're about to leave you to get on with your evenings, but before we do, just a quick little trailer for our next seminar. It is taking place on the 19th of March at 5 o'clock. Jennifer Youngs and Lee Kelleher, who are also members of our private law team, will be talking about covert recordings. So yet again, another feature of this new world that we're inhabiting, the law finally catching up with smartphones and social media. Thanks so much for coming, and we really hope that you can make the next seminar.
Thank you very much.